All rise.
The Kosovo Specialist Chambers is now in session. Please be seated.
Good morning and welcome everyone in and outside the courtroom. Before we start, pursuant to my decision setting the date for this initial appearance, the photographers are permitted to take a few photos for 1.5 minutes. And like I did yesterday and the day before, I will ask you not to take pictures of the accused with the security guard in the same picture. So if you can focus on the accused only for the pictures of him. Please proceed. Thank you. Thank you very much. Mr. Court Officer, could you please call the case?
Good morning, Your Honours. This is case number KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Vaseli, Recep Selimi, and Jakub Krasniqi.
Thank you, Mr. Court Officer. Before asking those present in the courtroom to introduce themselves, I would like to remind everyone of a few rules that must be observed at all times in order to make courtroom proceedings smooth. Please make sure you activate your microphone before speaking and you switch it off as soon as you finish. Talk slowly and clearly, as we have interpretation from and into Albanian and Serbian. Wait 5 seconds before responding to me or a party or participant in order to allow the interpreters to finish the interpretation. What is said in this hearing is transcribed in real time and will be reflected in a transcript available to the parties and to the public after the hearing. I would like to remind the parties that certain information in this case is subject to protective measures and confidentiality orders. These include confidential information that has been redacted from the confirmed indictment as to the identity of certain individuals, dates, locations, and other information. Confidential information must not be disclosed in open session. If any party or participant must go into private session and refer to any confidential information, please indicate the reasons. Now, I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Good morning, Your Honor. Appearing on behalf of the Specialist Prosecutor's Office this morning are the Deputy Specialist Prosecutor, Alex Whiting, Head of the Legal Advisory Unit, Claire Lawson, Prosecutor David Harbach, and I am Senior Prosecutor Alan Teeger.
Thank you, Mr. Prosecutor. Now I turn to the defense.
Good morning, Your Honor. On behalf of the defense is appearing Robert Karels. The lead counsel will be appointed. That will be David Young. But due to corona measures at this moment, it will not be able for him at this moment to be present, but he will be probably arrive from the UK next week.
Thank you very much. I note also that Mr. Selimi is also present in the courtroom for the record. Now I turn to Madam Registrar, please.
Good morning, Your Honor. Registrar Fidelma Donlan.
Thank you, Madam Registrar. And for the record, I am Nicholas Guillou, pretrial judge for this case. The accused is appearing today for the first time before the specialist chambers, following the indictment confirmed against him. Mr. Selimi, would you please rise? Could you please tell us your full name?
I am Recep Selimi, born on 15th of March 1971.
What is your place of birth and what is your citizenship?
I was born in Acharev, Scanderia municipality in Kosovo.
And you have the Kosovo citizenship.
Yes, I have Kosovan citizenship.
Mr. Selimi. Let me now move to the procedural history of the case. On 26 October 2020, in my capacity as pretrial judge, I confirmed the indictment submitted by the specialist prosecutor against the accused, charging him with 6 counts of crimes against humanity, namely persecution, imprisonment, other inhuman acts, torture, murder, and enforced disappearance of persons, and charging him with 4 counts of war crimes, namely arbitrary detention, cruel treatment, torture, and murder. The accused was arrested in Kosovo on 5 November 2020. He was transferred to the detention facilities of the Kosovo Specialist Chambers in The Hague on the same day. Mr. Selimi, before we proceed any further, I have to make sure that you can follow the proceedings in a language that you can understand and speak. Can you confirm that you understand and speak Albanian?
Yes, I speak and understand Albanian very well.
By this, I am satisfied that you can follow the proceedings in Albanian, a language that you understand and speak, in accordance with Rule 92 of the Rules of Procedure and Evidence. Mr. Selimi, if at any moment in the course of the proceedings you are not receiving interpretation, please draw my attention to it immediately. Now, allow me to explain the specific purpose of the initial appearance for the benefit of the accused and those joining us in the public gallery and following the proceedings online. Today's hearing is not a trial. No evidence will be presented or debated, and the guilt or innocence of the accused will not be discussed or decided. The purpose of this initial appearance is regulated by Article 39 of the law and Rule 92 of the rules. According to these provisions, as pretrial judge, I shall have the charges in the confirmed indictment read to the accused in a language he understands and speaks. Confirm that the accused understands the indictment. Satisfy myself that the rights of the accused, in particular his right to counsel, are respected. Inform the accused that within 30 days of today's hearing, he will be called upon to admit guilt or plead not guilty on each charge set out in the indictment. If the accused wishes to do so, he may immediately admit guilt or plead not guilty. And finally, I shall also set other dates as appropriate in performing my functions as pretrial judge. I expect the parties to adhere to these matters, which I will address in turn. Should either party wish to discuss any other matter not expressly foreseen in the context of the initial appearance, they are invited to do so in writing by making a filing before me. First, may I ask you, Mr. Selimi, to confirm that you have received the confirmed indictment dated 4 November 2020 in a language you understand and speak.
Yes, I confirm that I received the indictment in the Albanian language in a redacted form, as you know. Thank you.
Thank you, Mr. Selimi. I will now ask Mr. Court Officer to read out the charges in the confirmed indictment as foreseen in Article 39 of the law and Rule 92. Mr. Court Officer.
In the confirmed indictment, the Specialist Prosecutor charges Mr. Recep Selimi with Count 1. The crime against humanity of persecution punishable under Article 13(1)(h) of the law. Count 2. The crime against humanity of imprisonment punishable under Article 13(1)(e) of the law. Count 3. The war crime of arbitrary detention punishable under Article 14(1)(c) of the law. Count 4. The crime against humanity of other inhumane acts punishable under Article 13(1)(j) of the law. Count 5. The war crime of cruel treatment punishable under Article 14(1)(c)(i) of the law. Count 6. The crime against humanity of torture punishable under Article 13(1)(f) of the law. Count 7. The war crime of torture punishable under Article 14(1)(c)(i) of the law. Count 8. The crime against humanity of murder punishable under Article 13(1)(a) of the law. Count 9. The war crime of murder punishable under Article 14(1)(c)(i) of the law. And Count 10. The crime against humanity of enforced disappearance of persons punishable under Article 13(1)(i) of the law. These crimes were committed between approximately April 1998 and August 1999 at a number of locations in Kosovo and northern Albania, including Bare, Bagore, Lapatish, Mayak, Potok, and other locations in Podojove, Drenok, and other locations in Rahovec municipality, Beriše, Lapušnik, and other locations in Drenoc municipality, Ferezaj, and other locations in Ferezaj municipality, Gilan in Gilan municipality, Jablanica in Jakove municipality, locations in Kačanik municipality, Klečka, and other locations in Lipljan municipality, Likot, and other locations in Skenderaj municipality, Maleševe, and other locations in Maleševo municipality, Voljake Cave in Klina municipality, Novoberde in Novoberde municipality, Zalash and other locations in Pristine municipality, Prizren and other locations in Prizren municipality, Suareka and other locations in Suareka municipality, and locations in Viti municipality, and Stahan and Kukesh in northern Albania. The crimes under counts 1, 2, 4, 6, 8, and 10 were committed as part of a widespread or systematic attack directed against the civilian population in Kosovo and northern Albania from at least March 1998 through September 1999. In particular, these crimes targeted opponents who were perceived to have been, 1, collaborating or associating with the Federal Republic of Yugoslavia, FRY forces, officials or state institutions, or 2, otherwise not supporting the aims or means of the Kosovo Liberation Army, KLA, and later the Provisional Government of Kosovo, including persons associated with the Democratic League of Kosovo and persons of Serb, Roma, and other ethnicities. The crimes under counts 3, 5, 7, and 9 were committed against persons not taking active part in the hostilities, and in the context of and associated with a non-international armed conflict in Kosovo between the KLA forces and the forces of the FRY and the Republic of Serbia, including units of the Yugoslav Army, police, and other units of the Ministry of Internal Affairs and other groups fighting on behalf of the FRY and Serbia from at least March 1998 to approximately 16 September 1999. In relation to these crimes, there is a well-grounded suspicion that Mr. Selimi is criminally responsible pursuant to Article 16(1)(a) of the law for committing as a member of a joint criminal enterprise the crimes committed under counts 1 to 10, or alternatively, committing as a member of the aforementioned joint criminal enterprise the crimes under count 1 to 10 by being aware that such crimes might be perpetrated in carrying out the common purpose of the joint criminal enterprise, and by willingly taking that risk and/or aiding and abetting the crimes under counts 1 to 10. In addition, and in the alternative, there is well-grounded suspicion that Mr. Selimi is criminally responsible pursuant to Article 16(1)(c) of the law as a superior for the crimes under counts 1 to 10.
Thank you, Mr. Court Officer. Mr. Selimi, I wish to remind you that this is not the time to contest the charges, but simply to acknowledge that you understand the charges. You will have ample opportunity to challenge the charges with the assistance of your counsel. Mr. Selimi, did you understand the charges contained in the confirmed indictment as read out to you by Mr. Court Officer?
Would like indeed to provide an answer to your question, but furthermore, he would like to address the court with a short statement.
Then, as long as it is short and related to the case, you have the floor, Mr. Selimi.
Thank you, Your Honor. I know that this is not the time or place to speak about the legitimacy of this court, because I know that this court was established by the Parliament of Kosovo. I would like to emphasize also that I, as a member of Parliament, opposed the establishment of this court, not as an expression of justice, but on the contrary. We wanted that justice be done by the institutions of Kosovo in Kosovo. Allow me to remind you, Your Honor, that after Kosovo declared its independence, Serbia took Kosovo to court, to the International Criminal Court, that this independence was illegal. The International Criminal Court decided in favor of Kosovo. But only a few months after International Court of Justice, the Serbian authorities decided to issue a document against the legitimate independence of Kosovo. So we do not think that a court should be established on the basis of what Serbia has decided. Now we are at this point where this court is a fact. I am here not as a member of Parliament who opposed the creation of this court, but as a member of the KLA, and as one of the founding members of the KLA, facing charges made by the prosecution and confirmed by you, Your Honor. Your Honor and Mr. Prosecutor, our roles here are separate. We are different parties, but please believe that our aim, the aim of all of us here, is to establish justice and the truth. I saw the indictment raised by the prosecution. It's a very serious indictment, and it is very unjust. It is inaccurate and unjust towards me, and it is unjust towards the fight and the war waged by my people, and it was supported by you. But this process will show that we were an oppressed people that fought for freedom. Our people's fight was just. Liberation, we fought for liberation, and our war was clean and just. And the fight will continue after this process, because anyone that has any suspicions about that, any doubts about that, will be convinced that we, the Kosovo Liberation Army, and myself have nothing to do with any criminal enterprise, as this indictment states. I fought against Serbia. I fought against the Serbian occupier, against Serbia that only brought evil to my country. Murder, displacements, humiliation, and genocide. That's what Serbia did in Kosovo. So that is why I say that I did my duty as a citizen of my country. I am only a person who fought for liberation. I started the fight for freedom with Adem Yashari, and we completed our fight with General Clark, with NATO. It is my duty and my honor to be here on the side of the Kosovo Liberation Army and our people. This is my duty, and I will carry that responsibility. We have to establish the truth. Everybody here has to establish the truth. The prosecution, you, Your Honor, this court, and this will be my aim, my primary aim in these proceedings. Thank you.
Thank you very much, Mr. Selimi. Let me just reiterate my question. Can you confirm that you understand the charges in the confirmed indictment? And I'm not saying that you agree with them, of course. I'm saying, can you just confirm that you understand them?
Your Honor, yes, I read them, and I understood everything that was written in the indictment.
Thank you very much. Now let me inform you of your rights before this court. The law on the specialist chambers and the rules of procedure and evidence guarantee you a number of rights. I will read out the most important ones. First, you shall be presumed innocent until proven guilty beyond reasonable doubt. In the determination of the charges against you, you are entitled to a fair and public hearing subject to any measures ordered for the protection of victims and witnesses. You have the right to be informed promptly and in detail, in a language which you understand, of the nature and cause of the charges against you. You have the right to have adequate time and facilities for the preparation of your defense and to communicate with the counsel of your own choosing. You have the right to be tried within a reasonable time. You have the right to be tried in your presence and to defend yourself through your counsel. You have the right to have counsel assigned to you and without payment if you do not have sufficient means to pay for it. You have the right to examine or have examined the witnesses against you and to obtain the attendance and examination of witnesses on your behalf. You have the right to have the free assistance of an interpreter if you cannot understand or speak the language used in the court. You have the right not to be compelled to testify against yourself or to admit guilt. You have the right to remain silent, and no adverse inference shall be drawn from your silence. You also have the right to make unsworn statements relevant to the case, and you may appear as a witness under oath. You have the right to lodge preliminary motions to challenge the jurisdiction of the specialist chambers, to allege defects in the form of the indictment, and to seek the severance of indictment. You have the right to receive, within 30 days of today's hearing, the supporting material to the indictment submitted for confirmation. You have the right to receive all statements of witnesses whom the specialist prosecutor intends to call to testify at trial in the language you understand and speak, namely Albanian. You have the right to receive immediately any information which may reasonably suggest your innocence or mitigate your guilt or affect the credibility or reliability of the specialist prosecutor's evidence as soon as the information is in his custody, control, or actual knowledge. You have the right that all material and relevant evidence or facts in possession of the specialist prosecutor be made available to you before the beginning and during the proceedings. This right is only subject to restrictions which are strictly necessary and when any counterbalancing protections are applied. You have the right not to be detained for an unreasonable period prior to the opening of the case, to request review of decisions on your detention, and to appeal such decisions directly before the Court of Appeal. You have the right to appeal directly before the Court of Appeal a decision on preliminary motion challenging the jurisdiction of the specialist chambers, and you have the right to seek leave to appeal other decisions. Mr. Selimi, you heard the most important rights that you enjoy in accordance with the applicable legal framework of the specialist chambers. Do you understand these rights?
Paul?
I confirm that I heard all the rights, yes. Thank you.
Thank you very much. I wish to inform you that according to Article 21(5) of the law, you may not represent yourself because you are currently in detention. Representation by specialist counsel is therefore mandatory. It is my duty as pretrial judge to ensure that your right to counsel is respected. To this end, I have noted the registrar's filing informing me of the assignment of duty counsel for the purpose of this initial appearance, and I have also noted what your counsel, Mr. Karls, has mentioned today, the fact that you intend to have a counsel appointed by the registrar. Counsel, would you like to add anything in this matter?
Yes, thanks. Yeah, it will be no surprise after also what you heard, the statement of my client, that we will submit a request for interim release in due course. We will not do that today, but in due course. And I want to stress on this specific topic that detention or arrest shall only be ordered when there are solid grounds, and that's to believe that there is a risk of flight, very important in this respect. I want to stress, and we all know my client provided cooperation before. Also what he said at this moment, and the way about his arrest, he was last week, he was contacted by the prosecutor's office, and he surrendered himself. So these are solid, specific indications that there is no risk, or no reasonable risk of flight. Furthermore, my client, I want to say, whatever he thinks about these allegations, about this procedure, about this court, there are no indications, whatever we know up to now, and that's important, that my client, that Mr. Selimi, that he will probably influence witnesses or destroy evidence or whatsoever. One of the main important, because there will be submissions done, you will be provided to the court. We will see that in due course when documents will be disclosed. But as far as we know, there is really no reason to believe whatsoever that Mr. Selimi, that is what only, not what other people may have done or will do or whatever, that he will influence witnesses or temporal evidence or whatsoever. And therefore, and what Mr. Selimi also stressed, indeed, he will fully cooperate with this court and provide all answers as needed, just to that is what I have to stress at this moment.
Thank you very much, Mr. Karls. May I just ask you to link with your client in the following hours or days to submit all relevant requests to Madam Registrar regarding the appointment of counsel, as you mentioned.
Yeah.
And I also request the Registrar to make a filing in the case record informing me of any relevant decision in this regard. I will now turn to the possibility for the accused to enter a plea, if any, in accordance with Rule 92. Mr. Selimi, within 30 days from today, you will be called upon to admit guilt or plead not guilty on each charge in the confirmed indictment. If you wish to do so, you may choose to immediately admit guilt or plead not guilty. I would therefore like to ask you, Mr. Selimi, if you have had the opportunity to discuss the charges in the confirmed indictment with your counsel, and if you are prepared to enter a plea at this time. If this is the case, I invite you to stand up while you plead.
Yes, Your Honor. I had sufficient time to look at the indictment together with my counsel, to analyze it, to understand it, and allow me to say here that I feel not guilty in relation to all the charges in the indictment.
Thank you, Mr. Selimi. I will just ask you for clarification. It might be a translation issue. Can you confirm that you plead not guilty on all count? Because the translation I got was, I feel not guilty. And for procedural reasons, I need to have a very clear sentence from you. Thank you.
I usually declare what I feel, but I will repeat it for the procedure, for the proceedings. I plead not guilty to all the charges in the indictment.
Thank you, Mr. Selimi. That's very clear. Now let me move to the working language of the proceedings. In the scheduling order for this initial appearance, I asked the parties to make submissions on the working language to be used in the present case, according to Rule 8. Mr. Prosecutor, I know you've already made submissions on this 3 times. I will ask you to do it again for the benefit of the defense. Thank you.
Yes, thank you, Your Honor. It continues to be our position that the working language should be English.
Thank you, Mr. Prosecutor. Mr.
Also,
Kals.
that's the same request from the defense that the working language will be in English.
Thank you very much. I will issue an order in due course on this matter. As indicated in the order regarding this initial appearance, I will schedule a status conference, pursuant to Rule 96, to be held shortly after the initial appearances of all the accused. The purpose will be to review the status of the case and to organize exchanges between the parties to ensure expeditious preparation for trial. Mr. Selimi, I wish to remind you that you have the right to attend the status conference with your counsel. However, with your written consent and after receiving advice from your counsel, pursuant to Rule 96.2, the status conference may be attended by you in person with your counsel participating via video conference link, by your counsel with you, Mr. Selimi, participating via video conference link, or it may also take place in your absence with your counsel participating via video conference link or present in the courtroom. I would now like to ask the parties for their views on a suitable date for the status conference to be held on or after Wednesday, 18 November. And I will also ask the defense, if possible, to indicate whether you or the appointed counsel, if you already know, would participate in person or via video conference. Mr. Prosecutor.
Again, Your Honor, as the court is aware, we are available at the court's convenience, and a date on or after the 18th is suitable.
Thank you, Mr. Prosecutor. Mr. Kals.
Thanks. Also, the defense will be available at the court's convenience. However, we request you to put the date as late as possible in this month, during this month, because also Mr. David Young, he would like indeed to be present himself, but yeah, the prosecutor's office had a long time to prepare this. We are just entering this case. So if possible, and I know we have an issues with time limits for where we have to deal with for disclosure, but if possible, at the end of the month. Thank you.
Thank you, Mr. Karls. As you rightly pointed out, I have to strike the right balance between giving enough time to the defense to be present and at the same time not delaying the disclosure process, because this is for the benefit of all the defense teams. You will receive a scheduling order that will include the agenda in due course. I will also ask the parties for written submissions on the topics of the status conference. I intend to schedule the date for written submissions of the SPO on Friday, November 13th, and for the defense on Tuesday, November 17th. And after the status conference, I will issue a decision on the specialist prosecutor's disclosure obligations in accordance with Rule 102 and on the redaction regime for the proceedings. At this point, I would like to ask the parties whether they have other issues that they would like to raise. I remind the parties to give prior notice should any submission require the disclosure of confidential information so that appropriate measures may be taken. And Mr. Prosecutor, you also have the floor if you want to say a few words about the submissions of the defense a couple of minutes ago. Mr. Prosecutor.
That's much appreciated, Your Honor. We will, of course, respond in detail to any submissions by the defense on that issue, focusing on the determining factors for detention and provisional release, including the array of determiners ranging from the severity of the charges, the nature of the charges, and so on. So we will be pleased to respond in detail. Apart from that, and I appreciate the opportunity, we have nothing further.
Thank you, Mr. Prosecutor. Mr. Karls.
At this moment, Your Honor, also nothing further. We will submit submissions in due course. Thanks.
Thank you, counsel. I would now like to ask the accused whether he has any issue he would like to raise regarding his arrest, transfer, or detention. Mr. Selimi.
No, I have nothing in particular to add. I totally understand the rules that have to be applied for me to come to this court of law. Therefore, I abide to them, and I have nothing else to add.
Thank you, Mr. Selimi. Finally, I inform you that I will issue a decision ordering the specialist prosecutor and the registrar to reclassify their filings and prepare redacted versions, as the case may be, so that the defense has access to it as soon as possible. Mr. Selimi, as you remain in detention, I would also like to inform you that you may challenge your detention on remand in accordance with Rule 57, and this will be dealt with in written rulings. This concludes today's hearing. I thank the parties and the registry for their attendance. I also wish to thank the interpreters, stenographers, audiovisual technicians, security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.